Hi everyone, welcome again to the Basic Philippine Law and Jurisprudence channel. We are still on the series of lectures in property and land laws. Our topic for today is possession. Okay, Article 523 of the Civil Code defines possession as the holding of a thing or the enjoyment of a right. Okay, so if it is a corporeal thing, it is the holding or seizure of the thing. If it is a right, then the enjoyment of it would constitute possession. Article 530 also tells us that the objects of possession can only be things and rights, okay, which are susceptible of being appropriated. So things and rights which are capable of being appropriated may be possessed or may be the objects of possession. Now, what are the requisites of possession? Okay, there must be a holding of a thing or enjoyment of a right or material occupation. If it is a tangible thing, it is the occupation or seizure of that tangible thing. If it is a right, it is the enjoyment of the said right, which constitutes possession. There must be the intention to possess. The persons without legal capacity, such as minors or demented persons, might not have the intention to possess. Okay, so the intention to possess must be present. And the intention to possess must be in one's own right. Possession may be exercised by the owner for himself or through a representative possessing the thing in his behalf. Okay, so the intention to possess must be in one's own right and must not be in the name of another person. So he must be possessing or intending to appropriate the thing in his own right. Okay, now what is the extent of possession? It may constitute actual possession, which is occupancy in fact of the whole or at least substantially the entire property. Or it may be constructive possession, which is occupancy of a part in the name of the whole. Now, we go now to the kinds of possession. Okay? Possession may be exercised in one's own name or in the name of another. If you are possessing a land, okay, and you are occupying the land as owner of the same, that is possession in one's own name. But if you are possessing, for example, a residential house, but you are possessing it because your sister, who is the owner of that house, is in another country. Okay, so you are merely possessing the said property in the name of another, which is your sister, which is the owner, which is in another country. Article 525 tells us that the possession of things or rights may be had in two concepts, either in the concept of owner or in that of holder of the thing or right to keep or enjoy, the ownership of which pertains to another person. So again, possession may be in the concept of owner or in the concept of holder. Okay, possession in the concept of owner is if you are the owner of a certain property and you are possessing it at the same time, that is possession in the concept of owner. Okay, possession in the concept of holder. How do you understand possession in the concept of holder? The owner of the thing as well as the holder of the right to possess belongs to two different persons. So example, a certain land, okay, which is being rented out to another person. Okay, the naked ownership belongs to one person, okay, and the right to possess the thing as lessee belongs to another person. Okay, so that is possession in the concept of holder. So the lessee who is in possession of the property is possessing it in the concept of holder of the right. the right to lease or to enjoy the property. Okay. Article 526 tells us the distinction between possessor in good faith and possessor in bad faith. What is possessor in good faith? He is not aware that there exists in his title or mode of acquisition any flaw which invalidates it. While a possessor in bad faith is one who possesses in any case contrary to the foregoing. So, a possessor in good faith is one without knowledge of any flaw, okay, regarding his title or his right to possess the property. A possessor in bad faith is aware of a flaw, okay, regarding the possession of the property. Mistake upon a doubtful or difficult question of law may be the basis of good faith. The presumption is always in favor of good faith. He who alleges bad faith has the burden. Possession acquired in good faith does not lose this character except in the case and from the moment facts exist, which show that the possessor is not unaware that he possesses the thing improperly or wrongfully. It is presumed that possession continues to be enjoyed in the same character in which it was acquired. So, the thing to remember with respect to possession in good faith is that it is always presumed, and whoever alleges the contrary has the burden of proving that he possesses in bad faith. And once possession in good faith is acquired, it continues. Okay? It continues to be considered as a possession in good faith unless from the moment facts exist that he became aware of the flaw which invalidates his title. Possessor in the concept of owner. Every possessor has a right to be respected in his possession, and if he is disturbed, he shall be protected or restored to the said possession by the means established by the laws and the rules of court. A possessor deprived of his possession through forcible entry may within 10 days from the filing of the complaint present a motion to secure in the action for forcible entry a writ of preliminary mandatory injunction to restore him in possession. The court shall decide the motion within 30 days from filing. Remember that if you are everyone is entitled to be respected in his possession. So one who is in possession of a property has a right to peacefully possess the said property. Okay, and if he is disturbed in his possession, he may avail of the action interdictal, okay, which under the law are the remedies that would entitle him to be restored or to be protected in his possession. Okay, however, Article 540 tells us that only possession acquired and enjoyed in the concept of owner can serve as a title for acquiring dominion. Article 540 speaks of acquisitive prescription. So for you to be able to acquire a property through acquisitive prescription, the possession should be in the concept of owner. Diba, remember we discussed the distinction between possession in the concept of owner and possession in the concept of holder. So a possession in the concept of owner means that you are possessing the property, you are enjoying the property because you are the owner thereof. Or it is an attribute. The enjoyment of the property is an attribute of your ownership. Okay. However, a possessor in the concept of holder means that he is enjoying the possession of the property not because he is the owner thereof, but he is the owner of the right to possess. Like, for example, a lessee or a usufructuary. So a lessee, no matter how long his possession of the property, it cannot vest him title through acquisitive prescription. Why? Because he is not possessing in the concept of owner. So even if he is renting the property, say for a period of 100 years, it would not still make him the owner of the property. Okay. A possessor in the concept of owner has in his favor the legal presumption that he possesses with a just title and he cannot be obliged to show or prove it. If you are in possession of a property and you are possessing it in the concept of owner, there is a presumption that he possesses with just title. Okay, now let us now go to the kinds of title. What do you mean by just title? It is title that is true and valid, and title acquired through prescription must be. Okay, on the other hand, colorable title is a title acquired by a person who bought the property in good faith from one who is not the owner but whom he believes to be the owner. So, colorable, there is a color of title. Putative title, on the other hand, is the title of the person who bought the property but there was no mode of acquiring ownership. Example, if the person who sold the property is not the owner of the same. Okay, so it gives the buyer thereof putative title. Okay, the case of Quevedo versus Court of Appeals. Respondent said that he is the lessor of a parcel of land with residential house. He, as a lessor, and the petitioner entered into a lease agreement of a portion of the residential house. After the expiration of the extended lease, the petitioner continued to possess the premises, but without payment of rent. Now, in his answer, he stated that the respondent bought the lot. So there was a sale with the understanding that as soon as the petitioner would be in a financial position to do the payment, the former will transfer the title. Thus, in the meantime, a lease contract was executed with the parties. However, the respondent claimed that he was not given the chance to pay the purchase price. Okay, now the Supreme Court said and defined possession by tolerance in this case as follows. Possession by tolerance is lawful, but such possession becomes unlawful when the possessor by tolerance refuses to vacate upon demand made by the owner. A person who occupies the land of another at the latter's tolerance or permission without any contract between them is necessarily bound by an implied promise to vacate upon demand, failing which a summary action for ejectment is the proper remedy. Second, the private respondent may bring an action for unlawful detainer, even though he is not the titled owner of the leased property. Why? Because he is possessing it in the concept of a holder. Such action has for its object the recovery of the physical possession or the termination of who is entitled to possession de facto of the leased premises and not the ownership of the lot. Remember the provision that every person who is in possession of a certain property is entitled to be respected in his possession, regardless of the nature of his possession of the property. If he is in possession thereof in the concept of holder, then he is also entitled to possession because the action interdictal actually discusses or resolves only the issue of who is the one entitled to the rightful possession of the property or who has prior possession of the property. The only issue to be resolved in unlawful detainer or desahusio is the actual physical or material possession of the property, independent of any claim of ownership by any of the party litigants. Those in actual possession under any right entitling them to the use may maintain an action for ejectment against the wrongful possessor. Thus, a mere lessor may file such an action. The underlying philosophy is to prevent breaches of the peace and criminal disorder and to compel parties out of possession to respect and resort to the law alone in order to claim what they claim are theirs. Petitioner is necessarily in prior lawful possession of the property, but his possession eventually becomes unlawful upon termination or expiration of his right to possess. His prior physical possession does not automatically entitle him to continue and does not give him a better right to the property. We now go to the case of Soriano versus Court of Appeals. Okay. The subject property was leased by the heirs of Soriano to the De Vera spouses, with Roman as their caretaker. Now, the heirs sold their 3 shares to the spouses Abalos. The spouses Abalos filed an application for registration of title over the lots sold to them. Now, the application was granted, but a day after the issuance of the decision, Roman, together with the other heirs, filed against Abalos an action for annulment of document. Okay? But the said case was dismissed. Now, the heirs of Roman filed with the Darab a complaint against Abalos for security of tenure. The spouses Abalos moved for the issuance of an alias writ and or writ of possession over the property. The Supreme Court ruled that a judgment in a land registration case cannot be effectively used to oust the possessor of the land, whose security of tenure rights are still pending determination before the Darab. Stated differently, the prevailing party in a land registration case cannot be placed in possession of the area while it is being occupied by one claiming to be an agricultural tenant. In other words, when a decision was rendered declaring a person to be the owner of the property, that judgment does not necessarily include possession because possession, okay, may be granted to another person while the naked ownership belongs to a different person, such as in this case. So the possession is still being litigated in the security of tenure case in the Darab. So it cannot be, even though there is a favorable judgment, okay, in favor of a party, okay, regarding the ownership, the naked ownership of a property, that judgment does not necessarily include possession. The decision continues as follows. Ownership confers certain rights to the owner, among which are the right to enjoy the thing owned and the right to exclude other persons from possession. On the other hand, possession is defined as the holding of a thing or the enjoyment of a right. Literally, to possess means to actually and physically occupy a thing with or without right. Possession may be had in 2 ways. Possession in the concept of owner and in the concept of holder. A person may be declared owner, but he may not be entitled to possession. The possession may be in the hands of another, either a lessee or a tenant. So a judgment of ownership, therefore, does not necessarily include possession as a necessary incident. Okay? Such declaration pertains only to ownership and does not automatically include possession, especially when there is a third party occupying the said parcel of land in the concept of an agricultural tenant. While the issue of ownership has been laid to rest in the final judgment in the land registration court, the right of possession is still controverted. This is precisely what is in issue in the security of tenure case before the Darab. So the exercise of their rights of ownership are subject to limitations that may be imposed by law. We now go to the case of Yu versus Pakleb. Petitioner purchased the subject lot from Javier. Javier purchased the lot from Rebecca, who in turn acquired it from the respondent and his wife. The title of the property, however, remained in the names of the respondent and his wife. At the time of the turnover, a portion of the lot was occupied by Pakleb, respondent's son, and his wife as tenants. Petitioners allege that they exercise ownership rights as well as enjoyed open, public, and peaceful possession over the property from September 1992 until September 1995. During this time, respondent was in the US. Upon respondent's return to the Philippines, he allegedly entered the property using force, threat, intimidation, ousting the petitioners and their trustee Ramon. Now, despite repeated demands, respondent, as registered owner of the property, refused to vacate the premises. Okay, again, the Supreme Court found occasion in this case to define possession. To possess means to have, to actually and physically occupy a thing, with or without right. Possession always includes the idea of occupation. So it is not necessary that the person in possession should himself be the occupant. The occupancy can be held by another in his name. Without occupancy, there is no possession. So in other words, the Supreme Court distinguish in this case, okay, possession in one's own name and possession in the name of another, or possession in behalf of another. So two things are paramount in possession. First, there must be occupancy, apprehension, or taking. Second, there must be intent to possess. Here, the petitioners failed to establish that they had prior physical possession to justify a ruling in their favor. So the tax declarations and receipts in the name of the respondent establish that possession of the respondent. The payment of real estate tax is one of the most persuasive and positive indications showing the will of a person to possess in concepto de dueño or with a claim of ownership. Possession in the eyes of the law does not mean that a man has to have his feet on every square meter on the ground before he is deemed in possession. So in other words, the Supreme Court also discussed constructive possession. In other words, the subject land was in the possession of the respondent's sons during the contested period. In other words, dispossession in behalf of another. As the registered owner, petitioner had a right to the possession of the property, which is one of the attributes of ownership. The evidence establishing respondents' continuing possession of the subject property, petitioner's allegation that respondent deprived them of actual possession by means of force and threat was untenable. Where a dispute over possession arises between persons, the person first having actual possession is the one who is entitled to maintain the action. Otherwise, a mere usurper without any right might enter upon the property by allowing himself to be ordered off, could acquire the right to maintain the action of forcible entry and detainer. Okay? We now go to the case of Garcia. So we are already through with the distinction between possession in the concept of owner and possession in the concept of holder, as well as possession in one's own name and in the name of another. Okay. Garcia versus Court of Appeals. Garcia sold the lot to the Magpayos. Now, the Magpayos mortgaged the land to PBCom. However, the Magpayos failed to pay the loan for which the lot was mortgaged. Hence, the lot was extrajudicially foreclosed. Title over the land was consolidated in favor of PBCom. Now, the Magpayos filed a complaint seeking the nullification of the extrajudicial foreclosure. The complaint was dismissed. PBCom filed a petition for the issuance of writ of possession over the land, which was granted. Upon service of the writ of possession, Mrs. Magpayos' brother, Garcia, who was in possession of the land, refused to honor the writ of possession and filed a motion for intervention. Possession and ownership are distinct legal concepts. Ownership exists when a thing pertaining to one person is completely subjected to his will in a manner not prohibited by law and consistent with the rights of others. Garcia exercised their right to dispose of what they owned when they sold the subject property to the Magpayo spouses. Possession may be had in one of two ways: possession in the concept of owner and in the concept of holder. A possessor in the concept of owner may be the owner himself or one who claims to be so. One who possesses as a mere holder acknowledges in another a superior right which he believes to be ownership, whether his belief is right or wrong. So in this case, the records show that petitioner occupied the property not in the concept of an owner, for his stay was merely tolerated by his parents. We held in Tanisa that an owner's act of allowing another to occupy his house rent-free does not create a permanent and indefeasible right of possession in the latter's favor. It is of no moment that petitioner was in the possession of the property at the time of the sale to the Magpayo spouses. It was not a hindrance to a valid transfer of ownership. On the other hand, petitioner's claim of ownership as successor to his mother's share in the conjugal asset is belied by the fact that the property was not included in the inventory of the estate submitted by his father to the intestate court. So he is actually possessing the property in behalf of another. So the writ of possession is also valid as to him, okay, because he is only possessing in behalf of another person. Okay, Tabuso versus Court of Appeals. The private respondents obtained a favorable judgment in an action for declaration of ownership of an unregistered parcel of land. The trial court ruled that abundant proof was presented establishing the private respondent's ownership over the lot and that possession of a portion of the lot by the petitioners was by mere tolerance. So that what were the evidences considered? They were tax declarations in private respondent's name and a demand letter to vacate. Remember, when we speak of possession, it is subjecting the thing to the control or to the action of our will, controlling the thing. So the sending of a demand letter to vacate is actually an indication or an exercise of the right to possess. Okay, for a period of more than 60 years, private respondents have been able to establish that they are the owners of the lot and that for the said period they have been open, continuous, and uninterrupted possession of the same. So the only substantial argument of the petitioners supporting their claim of ownership is the construction of a small house on the property. Okay, the fact that petitioner's house is only a barong-barong or makeshift shanty lends support. Private respondents claim that the former's presence on the property was merely tolerated. Possession and ownership are distinct legal concepts. Ownership exists when a thing pertaining to one person is completely subjected to his will in a manner not prohibited by law and consistent with the rights of others. Possession is defined as the holding of a thing for the enjoyment of a right. Literally, to possess means to actually and physically occupy a thing with or without right. Possession may be had in two ways: possession in the concept of owner and possession in the concept of holder. Possessors in the concept of owners may be the owners themselves or those who claim to be so. Those who possess as mere holder acknowledges in another a superior right which he believes to be ownership, whether his belief be right or wrong. The evidence shows that the occupation of the property by the petitioners is not in the concept of owners because their stay is merely tolerated. This finding is bolstered by the fact that petitioner Andrea, the daughter of Marcelo, was merely allowed by the previous owner Esteban to construct a small house on the lot. The claim of the petitioners that private respondents are not in actual possession of the land is unsubstantiated. Besides, it is not necessary that the latter actually stay on the property in order to prove ownership of the same. One of the co-owners executed a lease contract over it in favor of the tenant, which is clearly consistent with ownership. Because when you are the owner of the property, you can subject it to the action of your will. Carlos versus Republic. Okay, in this case, Carlos filed an application for registration and confirmation of title over a parcel of land. She claimed that she had been in possession of the land in the concept of owner for a period which is sufficient to vest ownership through acquisitive prescription. So the Republic opposed this. Now, the Supreme Court held that possession is broader than occupation because it includes constructive possession. When therefore the law adds the word occupation, it seeks to delimit the all-encompassing effect of constructive possession. Taken together with the words open, continuous, exclusive, and notorious, the word occupation serves to highlight the fact that for an applicant to qualify, his possession must not be the mere fiction. Actual possession of a land consists in the manifestation of acts of dominion over it of such nature as a party would naturally exercise over his own property. Maria no longer had possession of the property at the time of the application for the issuance of the certificate of title. Her mother had sold the property to Ususan Development Corporation. So petitioner herein acknowledges the sale of the property to Ususan and in fact promised to deliver the certificate of title upon its obtention. Hence, it cannot be said that her possession was under a bona fide claim of ownership. So under the law, only one who possesses the property under a bona fide claim of ownership is entitled to confirmation of title. So at the time of the filing of the application for registration, he's no longer the owner. So possession in the concept of owner is the one which is required for acquisition of title through prescription. Okay, let us now go to the rights of a possessor. Article 544 tells us that a possessor in good faith is entitled to the fruits received before the possession is legally interrupted. So when is possession legally interrupted? From the moment that the possessor in good faith became aware of the fact which invalidates or casts a doubt on his title. Okay, so that is the point where possessor in good faith turns into a possessor in bad faith. So prior to that, the possessor in good faith is entitled to the fruits of the property. So natural and industrial fruits are considered received from the time that they are gathered or severed. Civil fruits are deemed to accrue daily and belong to the possessor in good faith in that proportion. If at the time that good faith ceases, there is natural or industrial fruits, the possessor shall have a right to a part of the expenses of cultivation and to a part of the net harvest, both in proportion to the time of the possession. Now, the charges shall be divided on the same basis by the two possessors. However, the owner of the thing may, if he desires, give the possessor in good faith the right to finish the cultivation and gathering of the growing fruits as an indemnity for his part of the expenses of cultivation and the net proceeds. The possessor in good faith who for any reason should refuse to accept this concession shall lose the right to be indemnified in any other manner. Okay, now what are the expenses that the possessor in good faith enjoys the right to be reimbursed? Okay, necessary expenses. What are these expenses? They are those for the preservation of the thing. Okay, necessary expenses shall be refunded to every possessor, whether you are a good faith or bad faith possessor, you're entitled to be reimbursed of the necessary expenses. Why? Because if these expenses are not spent, then it would result in the loss of the thing because they are needed for the preservation of the property. But only the possessor in good faith may retain the thing until he has been reimbursed therefore. So the possessor in good faith has the right to retain the thing until he is reimbursed of the necessary expenses. If you are a possessor in bad faith, you don't enjoy any right of retention, but you have the right to claim reimbursement. Okay, what about useful expenses? What are these useful expenses? They are expenses which add value to a thing or augment its income or make it more productive or increase its usefulness. Example, in a house. Okay. If the house is being eaten by termites and you spend an amount of money to have preserve the property by um, hiring a person who specializes in stopping the termites from eating the wood in the property, then that would be considered as a necessary expense because they are needed for the preservation of the property. The same example, if in a house, you converted uh, the first floor into commercial stalls, so they add usefulness or value to the thing. Okay, so they are considered as useful expenses. So can these useful expenses be reimbursed to a possessor in good faith? The answer is yes. The possessor in good faith also has the right of retention. Okay, however, with respect to useful expenses, a possessor in bad faith, okay, cannot or does not have the right to claim the said useful expenses. Useful expenses shall be refunded only to the possessor in good faith with the same right of retention. So the person who has defeated him in the possession, having the option of refunding the amount of the expenses or of paying the increase in value which the thing may have acquired by reason thereof. If the useful improvements can be removed without damage to the principal, the possessor in good faith may remove them unless the person who recovers the possession exercises his option to refund. Okay? So the option lies with the person who is with the owner. So the owner can reimburse, okay, the useful expenses, the amount that was spent. Okay? And the possessor in good faith has the right to retain the property pending payment of the reimbursement. However, he also has a limited right to remove, okay, the useful improvements, provided that the owner does not exercise his right to reimburse the possessor in good faith and that it will not cause any damage to the principal thing. How about luxurious expenses? Okay, what are luxurious expenses? They add value to the thing, okay, but are incurred only for embellishment or for the convenience of particular possessors. So they cater to the personal whims and caprices of a possessor. Okay, can a possessor in good faith reimburse or claim reimbursement for the expenses for pure luxury? Okay, the answer is no. Expenses for pure luxury or mere pleasure shall not be refunded to the possessor in good faith, but he may remove the ornaments with which he has embellished the principal thing if it suffers no injury thereby, and if his successor does not prefer to refund the amount expended. Okay? So there are two rights of a possessor in good faith with respect to luxurious expenses, limited right of removal, or if the owner chooses, he may refund the amount expended in order to prevent him from removing the property. But he cannot claim reimbursement, regardless of the good or bad faith of the possessor. Now, what are the obligations of possessors? The possessor in bad faith shall reimburse the fruits received and those which the legitimate possessor could have received, and shall have a right only to the expenses mentioned in paragraph 1 of Article 546 and 442. A possessor in good faith shall not be liable for the deterioration or loss of the thing possessed, except in which case it is proved that he has acted with fraudulent intent or negligence after judicial summons. A possessor in bad faith shall be liable for deterioration or loss in every case, even if it is caused by or gratuitous event. Okay, so regardless of the reason for the loss, if a possessor is in bad faith, okay, then he can be held liable for the deterioration or loss of the thing possessed. While if you are a possessor in good faith, you're not liable for loss or deterioration, except if it is proved that there is fraudulent intent or negligence on the part of the possessor in good faith. After he has acquired knowledge that uh, his possession is flawed. Okay? Lopez versus PETC. So PETC, as lessee, was occupying 2 doors with mezzanine of what is known as the Lopez building in Baguio City. However, they were burned and seriously damaged. Now, the defendant proceeded to repair or rebuild the property. Now, the defendant failed to pay the monthly rentals. Okay? The defendant was a possessor in good faith and as such introduced the improvements and had the right to the premises until it was reimbursed the said amount by the owner of the property. Remember, the property was burned. Okay, so this is actually an expense of preservation. This is a necessary expense. And if you are a possessor in good faith, you're entitled to be reimbursed of the necessary expense. The principle of possessor in good faith naturally cannot apply to a lessee because as such, lessee knows that he is not the owner of the leased property. So, can a lessee be considered as a possessor in good faith? The case of Lopez tells us that no, neither can he deny the ownership or title of his lessor, knowing that his occupation of the premises continues only during the life of the lease and that he must vacate the property upon the termination of the lease. He introduces improvements on said property at his own risk in the sense that he cannot recover their value from the lessor, much less retain the premises until such reimbursement. Remember that when you are the lessee of a property, you're possessing in the concept of holder and you recognize the naked ownership of the other person. So if you introduce improvements or expenses for preservation, you're actually governed by the lease contract or by the provisions of the civil code on lease, and you cannot be considered as a possessor in faith. Okay? Josefa versus San Buenaventura. San Buenaventura is the owner of a parcel of land. Now, Josefa entered into a lease contract with San Buenaventura over the said property. Now, upon the expiry of the contract, San Buenaventura wrote to Josefa informing him that the lease would no longer be extended. But Josefa refused to vacate. Okay? San Buenaventura filed a complaint of unlawful detainer against Josefa. Josefa pointed out that because of his commitment to renew the contract, he had made renovations and improvements on the land. whether the petitioner is entitled to reimbursement for his improvements on the lease premises. So after the subject lease contract expired, petitioner was already unlawfully withholding possession of the lease premises. The private respondents, being mere lessees, knew that their occupation of the premises would continue only for the life of the lease, and as such, they could not be considered as possessors nor builders in good faith. So it is a reiteration of the previous Lopez case regarding on the issue of whether or not a lessee can be considered as a possessor in good. We now go to the case of Aquino versus Aguilar. In this case, the Aquino spouses are the owners of a house lot. Okay, this property has been occupied by Teresa's sister because the Aquinos were in the US. While the respondents were in possession of the property, the house previously constructed was demolished and a three-story building was built. Respondents occupied half of the third floor for the next 20 years without payment of any rental. So the petitioners, Aquino, sent letter to the respondents informing them that they are now in need of the premises and demanding them to surrender the property. However, they refused. So there was a complaint for ejectment that was filed. Respondents claimed that they had contributed to the improvement of the property as well as the construction of the building. Okay, so they are, in other words, they are claiming reimbursement. Does not apply to those who possess the property by mere tolerance of the owners without a contractual right. There is absolutely no evidence of any lease contract between the parties. Although the factual circumstances are somewhat similar, there is one crucial factor that warrants a departure: the presence of evidence that petitioners prohibited the respondents from building their own structure on a portion of the property. So that is what, although the occupancy of the property was through the permission of the owner. However, okay, there was a prohibition from the owner uh, telling them not to make any improvements on the said property. However, they still introduce improvements on the said property. So they cannot be considered as possessors in good faith. Okay? Moreover, no evidence was presented to show that the petitioners were aware of what was happening, that the respondents were constructing a portion of the building with their own funds and for their exclusive use and ownership. Neither were respondents able to present evidence that petitioners had agreed to share on the expenses. Okay? We now go to the case of Maneklang versus Bao. Again, this is a case explaining or clarifying what a possessor in good faith is all about. Okay, Santos died intestate. Now, the administrator of her intestate estate filed a petition asking the court to give him the authority to dispose a portion of his estate that is necessary to meet the debts. So the new despite absence of the notice to the heirs, the intestate court issued an order authorizing the administrator to sell or mortgage so much of the portion of the estate for the purpose of paying off the debts. Okay, so they executed a deed of sale in favor of the city of Dagupan over the parcel of land. So the city of Dagupan took possession and constructed a public market. However, there came a new judicial administrator. So the new administrator filed an action to annul the sale made by the previous administrator. So the Supreme Court said that a possessor in good faith is one who is not aware that there exists in his title or mode of acquisition any flaw which invalidates it. Can the city of Dagupan be considered as a possessor in good faith? We find no circumstance to have alerted the vendee, city of Dagupan to a possible flaw or defect in the authority of the judicial administrator to sell the property. Since good faith is always presumed, and upon him who alleges bad faith on the part of the possessor rests the burden of it was incumbent upon the administrator to establish such proof. The filing of the case alleging bad faith on the part of the vendee gives cause for cessation of good faith. Good faith ceases from receipt of the sum. So the city of Dagupan may retain possession of the property until it shall have been fully reimbursed the value in the amount of 100,000 and 5/9 of the purchase price. The case of Pahunar versus Court of Appeals. So in this case, Eluna bartered his 3-year-old male cow for a 1-year-old female carabao. So the female carabao, which is bore the brand art in her front and hind legs at the time she was acquired by Mauho. Pahunar learned that the disputed carabao was in the possession of respondent Eluna, so claiming that he was the original owner of the carabao, which got lost in 1974, petitioner demanded her return. He demanded also the delivery to him of the 2 offsprings of the carabao. When Eluna refused, despite demands, petitioner went to court to recover possession. Private respondents claim that the female carabao has been in their possession for more than 10 years, which is sufficient for him to acquire ownership through prescription. Okay, however, respondents are not possessors in good faith, as a possessor in good faith is one which is not aware that there exists in his title or mode of acquisition any flaw which invalidates it. Failure of a party to exercise precaution, acquaint himself with the defects in the title of his vendor, precludes him claiming possession in good faith. This duty to make a closer inquiry into the certificate of registration of the female carabao, which was the subject of the barter, should have performed, but he did not. So when the owner of a movable has lost or has been illegally deprived of his property, he can recover the same without need to reimburse the possessed. So because it was proved that he is not a possessor in good faith. We now go to the case of Escritor versus Intermediate Appellate Court. A lot was the subject of cadastral proceedings. Escritor, as claimant, filed an answer declaring his ownership over the lot, alleging that he acquired it by inheritance from his father. So the lot was adjudicated in favor of Escritor and he took possession of the property. On the other hand, Acuña filed a petition for review, contending that it was obtained by Escritor through fraud and misrepresentation. The court adjudicated the lot in favor of Acuña. Acuña filed a complaint for the recovery of damages against the petitioners for the fruits of the lot. Okay, the Supreme Court said that we cannot affirm the position of the AYAC. It should be remembered that in the first decision of the cadastral court, it was adjudicated in favor of Escritor, and said decision became final. Escritor honestly believed that he is the legal owner of the land. This cannot be categorized as a possession in bad faith. A possessor in bad faith is one in possession of the property, knowing that his title is defective. Here, there was no showing that Escritor knew of any flaw in his title. Okay? Bad faith is not transmissible from one person to another, not even to an heir. Bad faith is personal and intransmissible. Its effects must therefore be suffered only by the person who acted in bad faith. Respondent, having failed to prove fraud and bad faith on the part of the petitioners, will sustain the trial court's finding that petitioners were possessors in good faith and should therefore not be held liable for damages. Okay, because he relied on the first decision of the court. That is why the court held him as a possessor in good faith. Okay, we now go to the case of DBP versus Court of Appeals. To secure a loan, Pineda executed a mortgage over a parcel of land. However, due to default, the said mortgage was foreclosed and the property was acquired by DBP. Now, the Pinedas filed a complaint against DBP for the cancellation of the certificate of title. The DBP, in evident bad faith, caused the consolidation of its title in spite of the fact that the 5-year redemption period has not yet lapsed. Now, the question or the main issue in this case is whether DBP was in bad faith when it took possession of the lot. A possessor in good faith is one who is not aware that there exists in his title or mode of acquisition any flaw which invalidates him. Good faith is always presumed, and upon him who alleges bad faith rests the burden. It was therefore incumbent on the part of Pineda to prove that DBP was aware of the flaw in its title. This they failed to do so. The respondent Pineda argued that DBP's bad faith stems from the fact that DBP consolidated title despite the statement in the sheriff's certificate of sale to the effect that the land was subject to a 5-year redemption period. If no redemption is made within 1 year, the purchaser is entitled as a matter of right to consolidate and to possess the property. Accordingly, DBP's act of consolidating title and taking possession after the expiration of the period of redemption was in accordance with law. However, the legal propriety of the foreclosure of the land was put in question only after Opinion 92 declared that said land was covered by PD 27 and could not be subject to a foreclosure proceeding. So by law and jurisprudence, a mistake upon a doubtful or difficult question of law may be the basis of good faith. So it called for the opinion of the Secretary of Justice. Okay? And therefore, considering that it is a difficult question of law, okay, the Supreme Court construed the same as the basis of good faith. Okay, so it was only upon the service of some, okay, that good faith ceased. Okay, Agapito versus Agapito. So this case stemmed from a complaint for unlawful detainer filed by Marilyn against Onesimo. Marilyn alleged that she is the owner of a parcel of land and that for more than 10 years, Onesimo, her brother, has occupied the property by mere tolerance without paying any rent. However, Onesimo constructed a house on that property. Now, the issue is whether or not the CA correctly held that Onesimo is not a builder in good faith and hence not entitled to reimbursement of useful expenses nor to the retention of the premises pending reimbursement. Okay? Good faith is generally identified by the belief that the land is owned or that by some title he had the right to build, plant, or sow. So in this case, while she denied having knowledge of and consenting to the construction of the house, it remains undisputed that she never raised any objection to its construction and Onesimo's occupation. The property lies barely a few meters away from where she resides. The court finds that Onesimo as a builder and Marilyn as a landowner are both in bad faith. So the bad faith of one neutralizes the bad faith of the other. So in effect, Onesimo shall enjoy the rights of a builder in good faith. Okay, so the landowner is given two options. He may appropriate the improvement subject to reimbursement or he may sell the land. Okay? Padilla versus Maliksi. In this case, the spouses Padilla bought a parcel of land and they discovered that Maliksi constructed houses on their land. The spouses Padilla made repeated demands for Maliksi to vacate the premises. Maliksi, on the other hand, alleged that they believed that the land belonged to the Moses Guild. They claimed that they possessed the land and built their houses on the lot after receiving the Moses Guild's permission. The spouses Padilla, exercising their option to sell the land, stated that by filing the motion, spouses Padilla had in effect recognized Maliksi as builders in good faith. They did not accept the offer to sell. Whether the respondents may be considered as builders in good faith. The records show that the Moses Guild was a complete stranger to them. The lack of blood relation should have been enough to put respondents on guard and convince them not to rely on her claim of ownership. If respondents had looked into the ownership of the lot, they would have easily discovered that it was titled to another person, Pablo Padilla's mother. The burden of proving the status of a purchaser in good faith lies on the person asserting that status. So even though the presumption is always in favor of good faith, okay, the court held in this case that the burden of proving the status of a purchaser in good faith lies on the person asserting that status. Failing to substantiate their claims, respondents cannot be considered as builders in good faith. As builders in bad faith, respondents have no right to recover their expenses over the improvements that they have introduced. A builder in bad faith is entitled to recoup the necessary expenses incurred for the preservation of the land. However, respondents neither alleged nor presented evidence to show that they introduced improvements for the preservation of the land. Therefore, petitioner as landowners became the owners of the improvements on the lot, including the residential buildings constructed by respondents if they chose to appropriate the accession. However, they could instead choose the demolition of the improvements at respondents' expense or compel respondents to pay the price of the land and to pay the damages. Okay? We now move to the case of Coscosio versus Palileo. The house is, in this case, is a two-story building, and the leasehold right to the lot were bought by the respondent Palileo, who paid part of the purchase price and mortgaged the house to secure the payment of the balance. So the property was sold to Cosio under a conditional sale. Palileo remained in possession of the house as tenant. Petitioner Cosio subsequently insured the house against fire. After the action was filed by respondent Palileo against Cosio for the reformation of the deed of pacto de retro into a loan with an equitable mortgage. Palileo filed another action seeking the ejectment of Cosio, who it was alleged had entered and occupied the house without the knowledge and consent of Palileo. Cosio, to be a possessor in bad faith, we nevertheless believe that she is entitled to be reimbursed for her expenses in restoring the house to its original condition after it was partly damaged by fire, because such expenses are necessary. Remember, possessors in bad faith are entitled to be reimbursed of the expenses for preservation without right of retention. There is therefore no reason for the application of the principal accessio cedit principali, such as what was contemplated in cases of accession continua. For what petitioners did in this case was not to build a new house on the land of another. Rather, what they did was merely to make repairs on a house that had been partly destroyed by fire. Okay? It provides the refund of necessary expenses to every possessor, regardless of the good or bad faith. We now go to the case of Penn Development Corporation versus Leiva. In this case, Martinez noticed that the construction of Las Brisas fence seemed to encroach on its land. Upon verification, Martinez was informed that the fence of Las Brisas overlaps its property. Despite the notices, Las Brisas continued developing its property. While it may be true that they acquired in good faith and for value, this does not prove that they did not encroach upon respondents' land. Petitioners are not entitled to reimbursements for necessary expenses. The builder, planter, or sower in bad faith is entitled to reimbursement for the necessary expenses of preservation. However, in this case, respondents' lands were not preserved. Petitioner's construction, in fact, caused damage. So it is not uh, an expense for preservation. Okay? Respondent did not in any way benefit from petitioner's occupancy of the land. Okay? How is possession acquired? How do you acquire possession? Article 531 tells us that possession is acquired through material occupation, the seizure of the thing, for the exercise of a right, or by the fact that it is the subject to the action of our will, or by the proper acts and legal formalities established for acquiring such right. A possession may be acquired by the same person who is to enjoy it, by his legal representative, by his agent, or by any person without any power. But in the last case, the possession shall not be considered as acquired until the person in whose name the act of possession was executed has ratified the same without prejudice to the juridical consequences of negotiorum gestio in a property. In other words, it may be acquired by the owner himself, by his legal representative, okay, in which case the possession would be in the name of another, by his agent, by any person subject to ratification by the owner. If possession of hereditary property is deemed transmitted to the heir without interruption and from the moment of death of the decedent, in case the inheritance is accepted. Okay, so how is possession acquired? Through material occupation, to the exercise of a right, by subjecting it to the action of our will, through acts and legal formalities, through succession. Okay? One who succeeds by hereditary title shall not suffer the consequences of the wrongful possession of the decedent, if it is not shown that he was aware of the clause affecting it. But the effects of possession in good faith shall not benefit him except from the date of the death of the decedent. Remember, bad faith is not transmissible. So if the person in possession died and he was possessing in bad faith, meaning he was aware of a defect in his title, when he died and he transmitted the possession by his death to his heir, the heir did not acquire the possession in bad faith. Okay, so it will be presumed that he possesses in good faith. Okay. Minors and incapacitated persons may acquire the possession of things, but they need the assistance of their legal representative in order to exercise the rights of possession. So, minors and incapacitated persons, because they lack the capacity regarding the intention to possess, they can possess through their guardians or legal representative. Okay? Binay versus Banaag. The petitioners allege that they are the lawful owners of a parcel of land. Now, respondents, through force, threat, and intimidation, with bolos stuck in their waist, prevented Binay's son from gathering ripe roots of the property. Now, the petitioners filed an action for forcible entry. The respondents filed their answer alleging that they are members of the Iraya Mangyan tribe of Puerto Galera and that the land is part of their ancestral domain. Now, the petitioners presented a title as proof of their ownership. So the issuance of an original certificate of title to the petitioners evinces ownership from which their right to possess flows. Well settled is the rule that a person who has Torrens title is entitled to its possession. Also, the petitioner's title and claim of possession are coupled with tax declarations. Possession may also be acquired not only through material occupation, but also through juridical acts. So, for example, the execution of a deed of sale would qualify as a juridical act that would result in possession. Possession may also be acquired by the fact that a thing is subject to the action of one's will or by the proper acts and legal formalities established for acquiring such right. Possession can also be acquired through juridical acts to which the law gives the force of acts of possession, such as donation, succession, execution, and registration of public instruments, inscription of possessory information. After all, it has been held that one will not have actual or physical occupation of every square inch of the property to be considered in possession. Possession can be acquired not only by material occupation but also by the fact that a thing is subject to the action of one's will or by the proper acts and legal formalities established for acquiring such right. Possession can be acquired through juridical acts. These are acts to which the law gives force of acts of possession. Possession in the eyes of the law does not mean that a man has to have his feet on every square meter of the ground before it can be said that he has possession. It is sufficient that petitioner was able to subject the property to the action of his will. Petitioner's Torrens title and tax declaration serve as convincing proof of their right of possession over the subject property. Here we now go to the case of Ruiz versus Armada. Ruiz filed a complaint for forcible entry against Armada. She alleged that she is the registered owner of the subject property and she had been in possession of the same. On the other hand, respondents alleged that Reynaldo is the son of Lucio Armada, the rightful owner of the portion of the coconut land, and that Reynaldo had only continued the ownership and possession of his father, evidenced by a tax declaration. We considered certain circumstances that serve as indicators of one's prior physical possession. One of these is the existence of tax declarations in the name of the petitioners and their predecessors in interest. We have held that tax declarations are clear manifestations of possession and occupation of the land. Although they are not proofs of ownership, they are good indicators of possession. Okay. We held that prior possession of the lot was sufficiently proven by the evidence and the execution and registration of public instruments and by the fact that the land was subject to its will. The court held that although respondent did not immediately put the land to active use, it had caused the property to be registered and paid real property taxes. These are juridical acts that are sufficient to establish respondent's prior possession. It would be putting a premium in favor of land intruders who had spent months or even years in order to register their land and who had religiously paid real property taxes. They cannot immediately repossess their properties simply because they have to prove their literal and physical possession of the property. We now move to the case of Quezon versus Juan. In her complaint, respondent alleged that she acquired a parcel of land from Nugit through a deed of sale. Respondent, on the other hand, claimed that petitioners, through the use of force, entered a portion of her property without her knowledge and consent. Okay. Despite the sufficiency of her complaint, respondent failed to prove her allegations, most significantly the fact of prior possession. Possession can be acquired not only by material occupation, but also by the fact that a thing is subject to one's will or by the proper acts and legal formalities. Possession can be acquired by juridical acts. In this case, there was no ouster or dispossession that took place. Petitioner Quison's material possession of the property preceded the sale between respondent and moving. It was never proven that the subject property occupied by Quizon and Zabian encroached upon or overlapped the property bought by respondent from Lubid. The issue of ownership over the subject property has not been seriously and successfully intertwined with the issue of possession. It has definitely been established by Lubid, the vendor, and by the ocular inspection that the subject land is outside the property of the lot sold to the respondent. What are the acts which do not affect possession? Okay, previously we discussed the means by which possession is acquired. Okay, by the holding of the thing, by the fact that it is subjected to the action of our will, by the proper acts and legal formalities established by law. Now, what are those which will not affect possession? Okay, Article 536 tells us that in no case may possession be acquired through force or intimidation, as long as there is a possessor who objects thereto. He who believes that he has an action or a right to deprive another of the holding of a thing must invoke the aid of the court if the holder should refuse to deliver the thing. So force and intimidation will not affect possession or will not result in the acquisition of possession. Acts which are merely tolerated, those executed clandestinely and without knowledge of the possessor of a thing, or by violence, do not affect possession. Okay? We go to the illustrative case of Viloria versus Picho. In this case, Viloria bought from the government a parcel of land. But before there was a final deed of sale, the respondent, Nicanor, claiming to be the occupants entitled to preference, applied for the purchase of those portions for themselves. Contesting the said decision, Viloria filed an action to annul and to have the DA secretary execute a final deed of sale in her favor. So every possessor has a right to be respected in his possession, and whether he has title or not, he cannot be deprived of such possession. Examining the judgment, we find that all that is ordained is the dismissal of the complaint and the dissolution of the injunction. It does not adjudge possession of any portion of said lot to anybody or order the removal of any fence. Okay? Now, what if there are several possessors? What is the preference of possession? Article 538 tells us that possession as a fact cannot be recognized at the same time in two different personalities, except in cases of co-possession. If there is a question regarding the fact of possession, the present possessor shall be preferred. So whoever is presently in possession of the property shall be preferred. If there are two possessors, the one longer in possession, so that is why there is a need to establish, especially in action interdictal, prior possession. Okay? The dates of the possession are the same, the one who presents a title, and if all these conditions are equal, then it shall be deposited in court pending the determination of the issue of possession. Okay? Tequena versus Mendoza. In this case, respondent, brother of petitioner, had a dispute on the ownership of the land during the survey. Because of this dispute, petitioners filed a case against respondent claiming ownership and possession. Judgment was rendered for the petitioners. The, they went on appeal, and the appellate court reversed the trial court's decision. So, despite their dispossession in 1985, the petitioners did not lose legal possession because possession cannot be acquired through force or violence. For all intents and purposes, a possessor, even if physically ousted, is still deemed the legal possessor. Indeed, anyone who can prove prior possession, regardless of character, may recover such possession. However, possession by the petitioners does not prevail over that of the respondent. Possession by the former before 1985 was not exclusive, as the latter also acquired it before 1985. So the records show that petitioner's father and brother, as well as the respondent and her mother, were simultaneously in adverse possession of the land. Based on the respondent is the preferred possessor because benefiting from her father's tax declaration since 1926. She has been in possession thereof for a longer period. So the tax declarations can become evidence of prior possession. On the other hand, petitioner's father acquired joint possession only in 1950. Okay. We now go to continuity of possession. Article 543 tells us that each one of the participants of a thing possessed in common shall be deemed to have exclusively possessed the part which may be allotted to him upon the division thereof, for the entire period during which the co-possession lasted. A present possessor who shows his possession at some previous time is presumed to have held possession also during the intermediate period. One who recovers possession shall not be obliged to pay for improvements which have ceased to exist at the time he takes possession of the thing. One who recovers possession unjustly lost shall be deemed for all purposes which may redound to his benefit to have enjoyed it without interruption. Okay, how may possession be lost? Okay, by the abandonment of the thing. Although this does not apply to lands, because you cannot abandon lands. Even if a land is abandoned, does not mean that it will become res null use. So if this applies to movables. Okay. By an assignment made to another either by onerous or gratuitous title. So you have actually assigned or transferred, okay, your possession of the thing either by onerous or gratuitous title. By the destruction or total loss of the thing or because it goes out of commerce, or by the possession of another if the new possession has lasted longer than 1 year, but the real possession is not lost till after the lapse of 10 years. What do you mean by abandonment? It is the voluntary renunciation of all rights which a person has over a thing, thus allowing a third person to acquire ownership through occupancy. So there must be an intention to abandon such that hope of recovery is gone. Assignment is the complete transmission of the thing to another. Loss is when the thing perishes or goes out of commerce. Okay, you versus Delara. So in this case, a parcel of land was acquired by Philippine Realty Corporation. Several persons settled on the property and constructed houses thereon without permission from Philippine Realty. The first point of argument by the appellant is that Philippine Realty had lost possession because they have already abandoned the property because they failed to take action, showing lack of interest in the property. So the circumstances adverted to are insufficient to constitute abandonment, which requires not only physical relinquishment but also a clear intention not to reclaim or reassume ownership. And this abandonment cannot apply to land, as to which said mode of acquisition is not available. Okay, let us now go to possession of movables. Article 542 tells us that the possession of real property presumes that of the movables therein, so long as it is not shown that they should be excluded. Okay? The possession of movable property acquired in good faith is equivalent to title. Nevertheless, one who has lost any movable or has been unlawfully deprived thereof may recover it from the person in possession of the same. Remember, possession of movable property in good faith. Okay? If you have possessed a movable property and you know the owner of that movable property, that is no longer possession in good faith. Okay? You have the obligation to look for the owner and return the same or to surrender it to the authorities. Okay? Otherwise, that would constitute as theft. If the possessor of a movable loss or of which the owner has been unlawfully deprived has acquired it in good faith from a public sale, the owner cannot obtain its return without reimbursing the price paid therefor. Okay. How about wild animals? Wild animals are possessed only while they are under one's control. Domesticated or tamed animals are considered domestic or tame if they retain the habit of returning to the premises of the possessor. We have what is called the doctrine of irrevocability. Okay, possession in good faith of a movable is presumed ownership and is equivalent to title. Okay, so that is all for possession. Thank you for listening.